Good evening, viewer. Glad to have you here again on The Big Issue. I am Obi Chukwemeka Uti. The judiciary plays an indispensable role in preserving the rights of citizens and the stability of the society. Despite these salient roles, the judicial process is often painstakingly slow and leaves much to be desired. This has made people shy of using the courts for fear of the saying, justice delayed is justice denied. The concept of speedy dispensation of justice is rooted under Section 36 of the 1999 Constitution, as it speaks volume about how fair a trial takes. This is often used as parameter to measure the maturity, strength, and efficiency of any country's justice system. Case files are piled up across Nigerian courts. Plethora of criminal matters and civil suits remain pending in Nigerian courts, most times accruing from adjournments down to right of appeals, all these elongating the lifespan of matters in court. The public at different times have resolved to jangle justice due to lack of trust in the courts to dispense justice expeditiously, leading to extrajudicial killings of many suspects. With 80 justices at the Federal High Court, around 90 justices at the Court of Appeal, and about 16 justices sitting on matters at the Supreme Court, in a country of over 200 million population, judges are said to be overwhelmed. Many voices have therefore cried out for a deliberate effort at lifting Nigeria's justice system out of the multifaceted challenges confronting the judiciary. Where do we begin the rebuilding? I'm now being joined via Zoom by the Honorable Justice Dr. Adeshuyi Olateru Olagbegi, Emeritus Judge, Lagos State High Court. He's also a life member of the Executive Committee of the Nigerian Bar Association, a legal consultant, an arbitrator, and mediator. Honorable Justice, thank you for leading the conversation today on The Big Issue.
Thank you very much.
Let's start this way. With 24 years post-call experience in the bar, cutting across local and international practice, coupled with 13 years on the bench, it is no gainsaying that you are a compendium of Nigeria's jurisprudence. Please share with me your conception of justice in Nigeria.
My conception of justice in Nigeria really takes me to the history of this nation. And it takes me as well to the question about whether we have a constitution which is ideal for the country that we are in, having regard to our antecedents. You will notice that you started your introduction with the Constitution, Section 36 of the Constitution, requiring the imperativeness of fair hearing. And then you will see that the Constitution itself has several provisions about the creation of courts, the Supreme Court, the Court of Appeal, State High Court, Federal High Court, Sharia Court, Customary Court of Appeal, etc. That is all well and good, but my concept of justice within the narrative of the Nigerian situation is that we have unnecessarily limited ourselves to the system of courts that obtains in the Western nations without at all taking advantage of the various modes of arbitral settings which we historically had in this nation. I'm speaking specifically about dispensation of justice in the traditional systems, the obas, the emirs, and the obis, as the case may be. even before the advent of the European, British, or European or US concept of justice, we have always had a way and manner of dispensing justice. And it begins from even the family unit. Every family in many parts of this nation, particularly in Yoruba land, every family has an Olori Ebi that is called the head of the family. In times past, whenever there is a dispute, if it is civil, the matter goes first of all before the Olori Ebi of the family. And it is up to the Olori Ebi to invite some other senior members of the family to sit with him. And that setting provides a system where you can even encourage people to meet themselves halfway. That is to say, if there are two warring factors, Obi, can you hear me?
Yes, I can.
Okay. If there are two warring factions, you can appeal to their sense of justice, to their sense of religion. You can appeal to the sense of history that binds them. It's not a winner-take-all kind of thing. It is not one that meets the case of the claimant 100%. But at least, number one, it does resolve the dispute. It does keep them still friendly. And then it reduces that kind of case going to the law courts. Because, let it be clear, there are well over 50-60% of the cases in our law courts. They shouldn't be there at all in civil cases. There are matters which may have had to be addressed at the, what they call it, Igbemoa Leli, which is composed of high chiefs headed by the Olowo of Owo. In our case, for instance, the Olowo of Owo is a legal practitioner who has also had administrative experience in the civil service. So you have this setting. Then, of course, you have the arbitral setting, where the warring factors may have a recourse to having to sit, maybe with religious leaders. Even at club level, you can have senior members of the club sitting down with warring factors and warring factions and taking a look into the matters before them. So what I'm trying to say is that my concept of justice in Nigeria is that we have unnecessarily shackled ourselves by limiting ourselves to the orthodox means of settlement, of litigation, rather than taking advantage of what the Lord has given to us. And it is one area to look. If you take a look at the Constitution of the Federal Republic of Nigeria 1999 as amended, no role whatsoever is given to traditional rulers. And many of them these days, in Asaba, the Obi there, he's a professor. In many other parts in the north, they are retired generals who really have had lots of years of experience. And then they are also appointed for life. And rather than taking advantage of this enormous existence of personnel and giving our traditions and customs, you have totally alienated them and now conscripted them into this alien system. So we need to take another look.
It's no longer news that our justice system is fraught with many inadequacies, which has become a clog in the wheel of justice dispensation. Many lawyers and human rights watchers have at different times decried the snail speed at which justice is processed in Nigerian courts. One matter that comes to mind is the notorious case of Major Hamza Al-Mustafa versus the state and the murder of Kudirat Abiola, which lingered in court for 13 years. following series of adjournments and trials within trial. With your experience as one who has been on that adjudication seat for many years, why has quick dispensation of justice become a Herculean task in Nigeria, 62 years post-independence?
In matters like that, clearly there is a lack of integrity on the parts of the dramatis personae. If you probe deeply, and you isolate the dramatis personae as being the prosecutors, as being the defense lawyers, as being the courts themselves, you will find that there has been some evidence of lack of integrity. There is no question at all about it, because there is no issue that is so complex in criminal law which can take a period of 1 year, 2 years, 3 years, 4 years, 5 years, 6 years, 7 years, etc. So I think that the reason for that is quite clear, and we should probe particular cases in this light. Let me deal with other factors.
Okay.
The first one, for instance, is that if the matter is a felony, for instance, it has to get referred to the DPP for advice. So beginning from that stage, you want to be able to follow up to say, how long did it take for the DPP to offer the advice to prosecute? Then it goes to the prosecutor that's left the table of the DPP. It goes to the prosecutor. Now, the prosecutor needs as well then to be examined. Do you have all your witnesses? Have you really studied this case properly? Or are you merely glossing over issues? Have you prepared yourself in a way and manner that you are confident that all the requirements of a particular crime have been proved given the depositions that you have? Because if you have not, many times they go to courts and they ask for unnecessary adjournments under the pretext maybe that a witness is unavailable or some such other absurd reasons. So that is the stage of the prosecutor. The case of the defense lawyers as well, they too from time to time contribute to this, and they may seek adjournments in respect of matters which have some political overtone, maybe EFCC matters. Some defense lawyers may be hoping that the matters may be so frequently adjourned as to dovetail into a favorable political regime where indeed maybe an attorney general can just come to court one day and tell the court that he is filing what is called a nolle prosequi, that is to say, a notice of discontinuance of the matter. You will see that in all of this, there's one, a lack of efficiency. That's a total lack of insufficient knowledge of the matter, or a total lack of integrity. These two matters, ability and or competence and integrity, they matter a great deal.
Okay, successive administration installs chief justices of Nigeria. Each of them comes on board with different judicial reforms, practice direction, procedural rules, among others. For instance, the Administration of Criminal Justice Act 2015, which has been widely domesticated by states, was touted to come, to the rescue of removing many of these clogs. Notwithstanding all of this, justice still moves quite slowly. Do these reforms have any impact on speedy adjudication of matters?
Yes, you mentioned the Administration of Justice Act. that was, as you have rightly stated, designed to accelerate trial in criminal matters. And for instance, where before in the middle of a trial, the issue of admissibility of a document may occasion an adjournment in order to appeal an adverse ruling. The Act makes it such that it permits the matter to proceed until conclusion. Then upon conclusion, the party who is dissatisfied may then take the totality of the matter to the appellate court. So if you take it on face value, all these provisions, they should work ceteris paribus. That is to say, provided all things are equal. If they were laws that were located in a totally different environment from our own dear country, Nigeria, they would work because they are working elsewhere. And it brings to mind as well, when I was on the bench, when Tinubu was governor and Professor Yemi Osinbajo was Attorney General, they introduced a lot of massive reforms in civil procedure and criminal as well. I had the good fortune of being a member of the review committee at the time. And we introduced some really very revolutionary regulations in civil proceedings, which lawyers refer to as uploading of documents, whereby all the documents you intend to use, you file them with your case at the onset. So you don't come to the trial court asking for adjournment because you cannot really procure particular documentations. Now, it has worked to some extent, but you find that in our dear country, those who practice this law, whether it is criminal or whether it is civil, they have a way of circumventing all of this. And if you go before a judge and a judge says, okay, I must go on with this matter, overruling an application for adjournment, and the lawyer, there has been instances where lawyers have walked out on a court, a most preposterous thing to do, very unprofessional, and rushed to take out some kind of proceedings, maybe application for transfer of the matter. They will say the judge is biased, and I really would like a situation where in cases like that, the issue is treated on merit, and any such lawyer that has been found involved in that kind of ploy ought really to have his name struck off the register. In England, a few years ago, I was on vacation when the matter came before the Court of Appeal, and the lawyer was advancing a matter, he was advancing a case, advancing a principle which had been long settled by all the courts, and their lordships were so incensed that they said, look, this matter is so well settled. Coming up here to now re-argue it, it's really surely an abuse of court process. And they had this case referred to for consideration for by a disciplinary committee. So we really have, you can't stop all the lawyers from engaging in all these ploys, but at least you can ensure that if you do so on merit, yes, there's no problem at all with that, you are within your rights. But if it is found that you do so in bad faith with the intention only of frustrating the cause of trial and obstructing the cause of administration of justice, there really ought to be a punishment for that. So these matters, the laws are all there. What about those who practice it?
Now, let's take a look at the physical setting of our courtrooms. Many have lamented infrastructural decay, lack of basic facilities in Nigeria courts as one of the banes. It is even said that most courts lack recording facilities, thus compelling judges who resume sitting at 9 in the morning to take notes using longhand, regardless of the number of cases before them on a daily basis. How much effect does this have on speedy dispensation of justice in Nigeria?
I can tell you, because in Lagos State, we were one of the first courts to have proceedings recorded, having recourse to automatic recording machines. And it's made a lot of difference. And you can sit in there during proceedings and listen to arguments and indeed make your rulings as the case may be, if they are in respect of routine matters, admissibility, whatever. The law is so well settled. You can sit in there, you can make your ruling, and you can ask counsel to continue. When you do it in longer hand, it takes a hell of a lot of time. It wears down the judge. It stresses the judge, and you are not able to function optimally. So there's no question at all about it, that automatic recording machines are a most essential tool for efficient performance in the law courts. We have all along been talking about the judiciary. We have not spoken at all about the executive. We haven't spoken about the legislature. We are always in the eye of the storm, and it is not usually remembered that it is because whatever we do is so obviously notified to the public, because proceedings are they admit members of the public, they are public hearings. But we do not have the same means of casting telescopic views on what the legislature does and on what the executive does. And permit my saying it, because the law courts, electorally, for instance, because they are not an electoral asset, you know, executives, they pay less attention to them as they would. What I'm saying is that in circumstances like that, I remember El Rufai when he was minister and when he said that money was being demanded by members of the National Assembly so that a bill could go through. They will rush money to settings like that. But when the judiciary asks for money, ask for funding, because we don't go on strike, because we do not really have, as I said, electoral asset, we don't win votes, less attention is given to the judiciary. So I really would want a situation where the executive realizes that the judiciary does occupy a central role in the life of any state and improves the funding of the judiciary in their respective states.
Now, at the elementary level of government, it is taught that independence of the judiciary is sine qua non to a healthy democracy. The Nigerian constitution seems to have enough fire to protect the independence of the judiciary. But in reality, in spite of the statutory safeguards put in place, can we say that the Nigerian judiciary is truly independent?
On paper, yes, it is. And in practice, let me just use the experience of individual judges. When a matter is assigned to you, remember you have taken an oath to dispense justice to all manner of people without affection or ill will, and to be fair to all. Now, in doing that, you are on your own with your conscience and God. No chief judge is going to write your judgment for you. And if anyone attempts to do that, you can call the matter up and it can lead to serious consequences. So in that sense, a judge is independent. you make your own ruling, you give your own judgments, you listen, you take the cases, you listen to the lawyers, you take the evidence, consult the law books, and then you apply the law to the facts and you write your judgment. To that extent, yes, they are independent. But if you just mention the issue of the automatic recording machines, if a court lacks amenities, indeed, if a court does not have the complement of staff that it requires to function, then the CJ of that particular state may have to go cap in hand to the executive for more funding. So there could be ways of interfering with the independence of the judiciary. And one of it, of course, is to starve it of funds.
Central to the issue of quick dispensation of justice is the conversation on the decentralization of the Supreme Court to remove the burden of focusing on a central system to give final verdicts over all matters, criminal, civil, election matters, among others, from 36 states of the Federation. On the face of it, it appears a factor for delay. Do you agree with proponents of a decentralized Supreme Court? Do you think that's the way we should go?
Let me give you a short story about that. The Supreme Court is the apex court, and there has to be one Supreme Court which sits there to take a look at all appeals from the Court of Appeal. That is the jurisprudential setting that we have. And as a student in England, I remember at a law dinner, a woman who approached a young judge and said, "Oh, excuse me, Mr. Raymond, you mean that at your age, you are a high court judge and you can give judgment, sentencing the person to life imprisonment, etc., etc.? Oh, that's great. You never do make mistakes, do you?" Oh, and he said he makes mistakes. If he makes a mistake, he will be corrected by the Court of Appeal. If the Court of Appeal makes a mistake, it will be corrected by the House of Lords as they did then, but they now have a Supreme Court. Now, so we have to have one central Supreme Court. I agree that there ought to be many courts of appeal and that they should sit in many more parts of the country than they are now. But you see, I had occasion in my career to sit on election petition tribunal. I did in Yobe State, I did in Edo State, and I find that indeed, again, about half the cases really ought not to come if people who are charged with these matters did their jobs properly. And the INEC and all its staff, right down to the lowest rung, ought to approach their duties with a greater sense of responsibility and integrity. Elections happen all over the world, in US, in UK. It is not as if you don't have them petitioning against the results, but they are not really as flippantly done or as frequently done as they are here.
I actually asked that question because a country like America, which Nigeria fashioned a presidential system after, has actually decentralized her Supreme Court. Isn't that the way to go for Nigeria too?
By decentralized, you mean that you have a Supreme Court for the nation replicated in all the regions, for instance?
Yes.
No, I think the decentralization that I would subscribe to is a decentralization where you can identify certain matters. You can say, well, matters of contract, matters of tort, that they end up at the Supreme Court of a state. If you take issues of felony, for instance, and particularly where the life of the offender is at stake, it cannot or should not be made to end at the state level. It ought to go to the final Supreme Court. In other words, you know that in the past, many regions, in the West, for instance, we had an apex appellate court where matters in respect of certain subject matters ended there. It's a way, really, of curbing the volume of work that goes to the central Supreme Court. So, yes, I will support one overall Supreme Court, but some appellate court in the states where specified matters cannot go beyond that stage. It's been argued, for instance, that interlocutory matters ought not to go beyond the Court of Appeal. Why do you need to take a matter interlocutory meaning a ruling that does not determine a matter on its merits, maybe an issue of admissibility, for instance? Why should it have to go to the Supreme Court? This is one of the issues that has been with us for quite a while. So you can take a look at the subject areas and say, okay, well, this subject area, it ends in Lagos State. This subject area can go beyond Lagos State. That kind of decentralization, in quotes, is what I subscribe to.
In the last 30 minutes, I have been speaking with the Honorable Justice Dr. Adesuyi Olateru Olagbegi, Emeritus Judge, Lagos State High Court. Honorable Justice Olateru Olagbegi, thank you for sharing your thoughts with me on the big issue.
Thank you too for having me.
Thank you. Let's go on a quick break to take the news update. We will be right back. Stay tuned.